Well, good morning or good afternoon. Welcome to today's Venable Nonprofit Organizations Group monthly webinar, AI and Copyright, What Nonprofits Need to Know. I'm George Constantine, and I co-chair the Nonprofit Organizations Practice Group here at Venable, along with Janice Ryan. Artificial intelligence, definitely the use has exploded recently, not just within the business community, but also among nonprofits. Some of us here at the law firm are a little concerned that the adoption may be outpacing the legal developments and sort of the development of law in the area, particularly as applies to copyright. So there are a lot of unknowns, but also I think there are a lot of uses that are happening now that maybe need to be either reined in or at least used in a way that's consistent with some of these copyright law concepts. Thankfully, we have a great speaker today who is very well versed in this area, and she'll be able to share her expertise with you. Megan Kent is my colleague, a very seasoned intellectual property litigator and counselor. She advises many different types of organizations on IP protection, risks and claims, notable experience on AI issues and copyright. And I've had the pleasure of working with Megan for a number of years now. And many of you may recognize her name from emails. She's helped a lot of the nonprofit organization clients over the years on copyright issues as well. With that, I'll turn it over to Megan and let her get started. I know you all will enjoy this, and we will be promoting our next webinars to round out the rest of the year shortly, so stay tuned for that. Megan, over to you.
Thank you, George, and thank you everyone for joining today. So AI and copyright. This is definitely an area that is up in the air. There is a lot going on in this space, so I'm just going to start by doing a level set on what the sources that we're looking at right now are and what the state of the law is. That will be our first topic. Then we are going to talk about AI-generated works specifically and concerns with that, and to the extent your organization is using AI and the team members are using generative AI, what are some of the concerns and things that you should be thinking about? We will talk about training AI models using copyrighted content and what the state of the law is on that issue as well. And then finally wrapping up with some practical considerations, licensing, enforcement, and AI governance issues. So starting with the state of the law, we have some guidance from the Copyright Office, we have some guidance from the administration, and we are starting to get some guidance from the courts. So first up, the U.S. Copyright Office has published a report on copyright and AI, and it's done that in three parts. So we have, first part was about digital replicas, which relate really to a person's image, what you would think of as the right of publicity as opposed to strictly copyright. The second part related to copyrightability of AI-generated works, and the third part relates to training AI models using copyrighted materials. And these three parts of this report was a culmination of the Copyright Office doing roundtables, soliciting comments from stakeholders. And in fact, they got over 10,000 comments from different stakeholders, from creative folks as well as technology companies and everyone in between, and put that together. And the reports reference those stakeholder comments quite a bit and then reach various conclusions. So that's one source that we look to. And the U.S. Copyright Office has historically been a guidepost for Congress and often provides guidance at Congress's request, and their reports will often help form whether there is legislation needed or not. And so it's important to look at it from that perspective as well. We have had some guidance from the administration as well. The AI Action Plan was published in July, called Winning the Race, America's AI Action Plan. This was a result of the AI Executive Order from January, which was titled Removing Barriers to American Leadership in Artificial Intelligence. And we can actually glean quite a lot just from the titles of these two, the executive order and the action plan, both indicating that AI is something that the administration is actively looking to support and accelerate. The AI action plan has the stated goals of accelerating innovation, building out AI infrastructure, and enhancing global partnerships and security, and decreasing regulation to the end of accelerating that innovation and competition. It's been referred to as the next space race, sort of this AI race. The AI action plan itself did not reference copyright at all or intellectual property, but in the speech announcing the plan, President Trump stated there should be, quote, common sense application of AI and intellectual property rules. And he referenced that licensing everything was just not doable, and noted that China is not doing it, as in China is not licensing everything. And this seemed to mirror what many stakeholders in the technology space had been arguing in their comments to the administration and to the Copyright Office, that in order to be competitive, American AI developers should not be required to license everything. So that was sort of reflective of those comments. He also indicated that AI should be regulated at the federal level and not at the state level, which was reflected in the AI action plan. That said, we don't have any indication that there is legislation coming on the issue of copyright specifically at this point. Okay, and then our third bucket of law that we're looking to and guidance is case law. There are literally dozens of cases ongoing right now involving the question of whether using copyrighted content for training AI and AI models is an infringement or a fair use. And we've had 3 decisions in the last several months that we'll talk about in more detail. But again, there are dozens of litigations ongoing in the US and overseas. And they involve cases to do with images, text and language cases involving books and newspapers. There are software cases and there are music cases. In addition, there have been a handful of cases relating to copyrightability of AI-generated works. So we'll talk about those as well. So let's start with AI-generated works. And to the extent your organization is using generative AI, what are some of the concerns, including copyrightability and ownership, as well as potential risks associated with using these tools from a copyright perspective? So taking a step back, it has been well-settled law that to have copyright, you have to have human authorship. And this is an existing framework that was laid out in the Copyright Clause of the Constitution. The Supreme Court has talked about this. This case here that I refer to, the Naruto versus Slater case, that is also known as the monkey selfie case, you may have heard of, where a photographer, Mr. Slater, had set up a camera in the jungle. The monkey named Naruto had come along and clicked the button and taken photos of himself. And PETA, the People for the Ethical Treatment of Animals, had sued on behalf of Naruto, arguing that the monkey, should have ownership of the copyright and be able to enforce copyright in the photographs. Long story short, the court said no, human authorship is required, and Naruto being a monkey, he could not own copyright, and copyright did not exist in those photographs. So that's sort of the long-standing law in this space. This has now been translated to AI, and we have decisions from the Copyright Office and from district courts agreeing that human authorship is required. AI is not human, and so an AI-generated work cannot be protected by copyright. So a couple of examples here. The first, Stephen Thaler or Thaler, different pronunciations. I'm not sure which is correct. I should find out. He used a tool called Dabus, which I believe he developed himself, but a generative AI tool to create this artwork pictured here. The Copyright Office refused registration, saying there was a lack of human authorship because it was fully created using the AI tool. The DC Circuit affirmed, um, stating that the human author requirement rests on centuries of settled understanding, and the Court of Appeals for the DC Circuit affirmed this requirement. Another example here was Mr. Allen had used Midjourney, a popular generative AI tool, to create this artwork. And again, the Copyright Office refused registration, saying there was a lack of human authorship. Here, the artist argued that the prompts should be sufficient to create human authorship in the output, and that he had used over 600 different prompts, that he had to be quite creative in those prompts, and there was a lot of effort taken, and so that should be enough to create the human authorship. And the Copyright Office said, no, that's not enough. Doesn't matter how many prompts you have, you as the human author still don't know exactly what the AI is going to output. There are still many different ways that the output could turn out, even with all of those different prompts. And so you don't really have control over the expression. And so there is no human authorship. Here is another example, and this one helps us think about when you're combining AI works with human created works. And so this is often the case in practical space that your organizations may run into, where people are using generative AI as a tool. So part of their output is going to have a piece of generated work from generated AI, where some of it is going to be human authored. So here, this was a graphic novel where the author had created the text. So all of the text was human authorship. And they had used generative AI to create all of the imagery for the graphic novel. The Copyright Office initially registered, not realizing that AI had been used at all, but ended up refusing or canceling that registration and ended up reissuing it to say only the portions that were created by a human may be protectable. And so specifically, that was the text, as well as the arrangement, or excuse me, the selection, coordination, and arrangement of text created by the author and the artwork generated by artificial intelligence. So the text and then also how it was all put together was protected because both of those involved human authorship. So that helps us think about when people are using AI tools, AI as a tool, and coming up with works that are then incorporated into their work, you may still have copyright protection just because one piece of it was created using AI. All of the pieces that were created by the human are still potentially subject to copyright protection so long as they're sufficiently original and creative. And the Copyright Office report that I mentioned before talked about this in more detail. It explained and analyzed the level of human contribution that would be necessary. It gave the example of the prompts not being enough. So this is an example of the cat, the speckled cat. And the Copyright Office explained, this is the prompt, this is the output, but there are many thousands of different outputs that could have resulted from this prompt. And so this is not protected. That output is not protected by copyright. However, it said if human expression is recognizable, identifiable in AI output, that may be copyrightable. So for example, the Zari of the Dawn example that they talked about, where human authorship is combined with AI authorship, you still have protection over the human authorship. Okay, so in addition to the copyright issue, and copyright ownership of the output. There are various other potential risks that get discussed with using generative AI. So risks that are considered around the output include copyright infringement, right of publicity infringement, trademark infringement, so classic IP infringement issues. The output from generated AI could potentially infringe someone else's copyright. It could, and the concerns have been raised that, well, if these tools have been trained on all sorts of underlying materials, is there a chance that they will infringe on those underlying materials? And there certainly may be. We have not seen a significant amount of litigation on that issue or a significant number of claims, but that is certainly a concern that the output could infringe someone's work. Some of the generative AI tools have guardrails in place to try and prevent this, such that they are telling the tools that the output should not be a replica of the input on which they were trained on. I don't know how well those work, but it seems to be that they are working fairly well, since we're not seeing a lot of claims on that, but certainly still a risk that is out there. The right of publicity infringement concern is that you have a generated image that has a person in it, and it could potentially look like someone who actually exists in reality. So there is a concern that using someone's image without their permission. Trademark infringement issues, logos have been seen to pop up in outputs. Certainly, if the prompt has any reference to a trademark or a brand, that is more likely. And again, many of the tools have guardrails that they're putting in place or restrictions that they're putting in place to try and prevent these issues. So a couple of things to think about here is having human review. So just as you would for any other type of sort of third-party content that you're getting, if you hired a vendor, if you're reviewing material before it went out, you would have human review to check for sort of any obvious right of publicity concerns. If you see a celebrity in the image or someone that you recognize in the image, certainly that's something that you want to flag. If you see an obvious logo, you want to flag that. So continuing to have human review of content is going to be critical, just as you would before. You will also want to think about, if you think of the tool as a vendor, often when you are working with a vendor, you'll have guarantees or indemnification. So they'll warrant and represent that the work they're creating is original. It may include some indemnification obligations if claims are made as to the materials that they're creating for you. So if you think of it that way, some of the generative AI tools will have those types of contractual terms in them. Usually not the free versions, right? The free versions often won't have any sort of guarantees or indemnifications, but if you are entering agreements with a provider and you've got an enterprise tool or you're negotiating a specific agreement to use their tools, often they do have certain warranties or indemnification provisions, depending on the provider. So something that you'll want to pay attention to when you're deciding which tools you want to use or allow your organization to use. Another point to consider is how the output from the tool is used and also how any input is being used. So again, the free versions often will say that the output and the input, I mean prompts or any sort of information that you're providing to the tool, can be used for training. So they can take that and circle it back into the tool for training the tool. Oftentimes the enterprise versions or those separately contracted versions that you have will not allow for that and will allow a lot more security for any input as well as any output from the tools. So considerations, those are some of the risks and why you might want to pay pretty careful attention to the terms of service or the different tools. Okay, and now more specifically talking about digital replicas. So that goes to that right of publicity issue. But I want to talk about it a little bit more specifically because we have a lot more guidance on this point than really anything else in this space. The Copyright Office had done its first report on digital replicas. And as I mentioned, that Congress tends to look pretty carefully at what the Copyright Office says in its reports, and that report indicated that it thought that a new federal protection would be necessary for digital replicas. Currently, the right of publicity is a state protection and varies state by state. There's no federal law. And the Copyright Office said that it thought that a new federal protection was warranted. And so we have seen introduction of legislation called the No Fakes Act. And that was introduced in 2024 and then was reintroduced in both the House and the Senate in 2025. It has good bipartisan support. I don't know how quickly it will move, but certainly there is some support for this, and it would create a property right in a person's voice and visual likeness in the digital replica space, and create a certain takedown mechanism for any sort of digital replicas that appear in online. In addition to that, we have already seen pass the Take It Down Act, which was signed into law in May and will go into effect in May 2026. And it provides a notice and takedown process similar to the DMCA, the copyright provisions. So if someone is impacted by this, and this doesn't, I should be more specific, it only involves non-consensual intimate images. So it's not all digital replicas, but they're intimate images. But they could be AI generated or digital replicas, or they could be actual intimate images. And it creates a safe harbor for anyone hosting that content, so long as they comply with the notice and takedown provisions. So if your organization hosts any user-generated content, if you have any message boards or anywhere where the public can post content or members can post content, and you have, for example, your DMCA takedown procedures in place, you will also want to now have a Take It Down Act procedure, notice and takedown in place, so that you stay within the safe harbor for those non-consensual intimate images as well. Okay, we're going to move next to the state of the law with training AI models using copyrighted content. But before we do, I wanted to give you the CLE code, and I'll give it again at the end. But the CLE code is copyright 2025 with no spaces, just one word, copyright 2025, and it's not case sensitive. Okay, so looking at training AI models using content. Taking a step back, different models have been trained in many, many different ways and using many different forms of content. There are some models that have only used licensed content. There are some models that have also used open source or public domain content. There are some models that have gone out and bought books and scanned them and used that content for purposes of training. There are others that have just scraped the entire internet. And then there are some that have actively used content from so-called pirate libraries. So libraries of content that includes pirated content. So they're wide range, and some providers will be more vocal about the fact that they only use licensed content, and so they're more commercially safe than perhaps others. But we are seeing a lot of the litigation surrounding those that used, the scanned or the scraped or the pirate libraries, much less so than those that use licensed content. So for those that were using unauthorized content, let's say unlicensed content, we are seeing, again, dozens of different litigations. The claims tend to be direct copyright infringement as well as secondary copyright infringement. There are some Lanham Act claims and unfair competition claims that have been wrapped into some of them. But typically they're surrounding claims of copyright infringement. And the standard defense to these claims is the defense of fair use. And fair use is a defense to copyright infringement that's articulated in the Copyright Act. And the Copyright Act lays out 4 factors that you are supposed to consider in evaluating whether any particular use is a fair use. So the 4 factors are listed here on the screen. They are notoriously subjective, fact-specific. It is often hard to predict how a case will come out because it's so fact-specific, and the trier of fact really has to evaluate the different factors. There's no most important factor. You could have one factor going really strongly in your favor and the other 3 going against you, and you still succeed, or and vice versa. So it's very very subjective. But the factors are, the first is the purpose and the character of the use. So this includes whether it's a commercial use or whether it's a nonprofit or an educational use, or whether you're using it perhaps for purposes of commentary or parody. A classic example is, using an artwork to make and showing it in order to make commentary about it. You need to show it in order to talk about it. Other examples that have emerged in recent years include technology uses, and the question, the way this factor has panned out is whether the use is transformative. Are you transforming the work into something new and different? So that's the first factor. Often the first factor is very important in the analysis, and typically more so than the second and third. The second factor is the nature of the copyrighted work, which is how creative of a work is it? Is it, for example, a novel or a movie, as opposed to an instruction manual or some software code? That factor often is less important, although from time to time it becomes central to the case. The third factor, the amount and substantiality of the portion that's used in relation to the underlying work as a whole. So do you use only as much as you need to for your purposes, or are you using more than you need to? And even if you don't use the entire work, perhaps you're using, for example, in music, you're using the hook. So it's substantially significant. That will be evaluated. And then the fourth factor is the effect of the use on the potential market for the underlying work, or the value of the underlying work. And that can be the license market, or to sell the work, the underlying work. So that really looks more to the economic impact of the use. So the first and the fourth factors tend to be the most important, but not always. And we are seeing them probably being the most important factors in the AI context. Okay, so the Copyright Office again gave us a little bit of guidance. They had the third part of their report, and this report was over 100 pages. They went through just a ton of analysis, looked at all of the stakeholder comments, shared what the positions were of the different stakeholders with creators and authors, saying, look, if you allow people to use our content, it's going to destroy our livelihoods, diminish human creativity. And then the AI developers on the other side saying, if you require us to license, that will stifle development of AI technology. And then the Copyright Office offered its own views of each factor. Ultimately, the Copyright Office said, because fair use is so specific, And it really depends on the type of use. It depends on how the content was used to train the model. Are there guardrails in place to prevent exact outputs? What is the market for the underlying work? Is there a license market for purposes of AI training? All these sorts of questions in each case are going to be different. And so ultimately, sometimes there may be a fair use and sometimes it might not be. And so essentially the Copyright Office said, yeah, it might be a fair use, really depending on the circumstances. And as part of that, this report, they also talked about what might possible solutions be here for the fact that companies need AI developing companies need this content, but they don't want to what and there's all this infringement going on. What are potential solutions? For several years, some of the talk was there should be compulsory licensing. Perhaps there's a requirement that they pay a certain amount. And it seemed that, and what the Copyright Office reported was, stakeholders didn't like that idea. They didn't like the idea of compulsory licensing on either side. The creative stakeholders didn't, and the technology stakeholders didn't either. But not all, but the general consensus was towards voluntary licensing as a good marketplace solution for the situation that we're in. And ultimately, the result of this report was that the Copyright Office said it does not recommend legislation on the issue of fair use. And instead, it suggested that effective licensing options are the marketplace solution in the way that this should go. And the quote here says, effective licensing options can ensure that innovation continues to advance without undermining intellectual property rights. So that is what the Copyright Office proposed. Now, what have the cases said? So again, many of them are pending, and the decisions that we have just been at the district court level, and there will be appeals. So we don't have determination on this, but we can start to look at how the courts are evaluating the factors. The first was in February of this year out of Delaware. And this case was Thomson Reuters versus Ross Intelligence. This involved, lawyers will be very familiar with Westlaw and the West headnotes. And those have been copied and used for purposes of training an AI tool that would be used for legal research that was offered by Ross Intelligence. In evaluating the factors, the judge said this was not a fair use. And the critical factors for this were the first and fourth, as often they are. And the court said, look, this is a commercial use, and it's not a non-profit use, and it's not particularly transformative. You're using content from one research tool to create another research tool. And on the marketplace side, this is a direct competitor. You're likely to undermine the market for the underlying works, Westlaw and the headnotes. The next case we had, we had two come out in June, Cadre v. Meta, and then one we'll talk about in a moment. The Cadre v. Meta case, Northern District of California, and this was one of the author cases where there were, it was a class of authors had sued Meta for using their books for training Meta's LLM called Llama. And the judge there found this was a fair use. And again, the key factors were the first and the fourth factors. On the first factor, on whether this was, the nature of the use, while it is a commercial use, the judge said it was just so highly transformative with a further purpose and a different character that this weighed in favor of fair use. So the transformative nature of the work was really the critical piece here, that Meta was not just making more books, they were creating a large language model that served a very different purpose than the underlying books. And then on the fourth factor, looking at the marketplace considerations and the economic factors, the judge talked about the potential market harm pretty extensively. And it was fairly evident that the tool was not outputting exact copies of the books. So it wasn't going to diminish. People were still going to buy that book, right? They're not going to go and ask for the exact book to be output. However, these tools can output other books and thousands of them potentially, and potentially in the same genre or even in the same style of a particular author. And the judge talked about this fairly novel theory of dilution of the market, which has not historically been evaluated in copyright fair use cases. But now within the AI context has been brought up and saying this judge believed that that was a viable theory, and it was in fact the only viable theory of harm, but that the plaintiffs had not submitted evidence of that harm. And so he ultimately found it was a fair use, but seemed to be indicating potentially to other plaintiffs in other cases one type of harm that they should consider articulating. Okay, it was the day before, so right around the same time as the Meta decision, we have another judge in the Northern District of California in the Bartz versus Anthropic case, also issuing a decision on this issue related to books and the use of books to train an LLM. Again, it was a class of authors. And here, Anthropic had used the author's works to create a central library and to train an LLM. And it had gotten the content in two different ways that are important to the decision. One was that it had taken content from so-called pirate libraries, where it knew that the content was pirated content, pirated copies of the books, unauthorized copies of the books, and had nonetheless taken those and used them to create a central library. It had also transitioned after that to buying books, scanning them, and then training its LLM on those scanned books. But it had not removed the pirated copies of works from its central library. So we got a split decision where the judge said the download of pirated copies of works to create that central library is not a fair use. It cannot be a fair use. However, the purchase and scanning of copies to train an LLM was a fair use. And again, he focused on the transformative nature and that first factor, saying this was quintessentially transformative. And then, interestingly, he looked at the economic factor and reached the opposite decision of the other judge, rejecting a theory of that dilution type of harm, and said that is not something that we have adopted before, and the market harm has to look at your specific book, not the dilution of the market. And here the output wasn't going to displace demand for copies of the author's books. They weren't getting replicated in the output. So in this case, again, we have that piece that was found not to be a fair use, pirated copies of works. So that piece was set to go forward. Trial was set for that while the other piece was being appealed. Anthropic was under a lot of pressure. This is what it has said, because there were potentially trillions of dollars at stake because of the pirated copies of works that it had used. And so fairly quickly, the end of August, a settlement was announced. And the terms were shared at the beginning of September, and this has been in the news that the amount was $1.5 billion, which works out to about $3,000 per work that Anthropic had agreed to pay to the authors. The settlement hasn't been approved yet by Judge Alsup, but that is the status of it at the moment. And has been pointed to, and a lot of analysis has been done by the market sort of on this settlement and these numbers. Okay. I see I have a question before we go to the practical considerations about what constitutes nonprofit educational purposes for fair use. So this is important, I think, for nonprofits to consider. And I've run into this a number of times with nonprofit clients because the Copyright Act says as one of the factors, the purpose and character of the use was it for a nonprofit educational purpose? So if you are a nonprofit organization, don't think that all of your use is automatically a fair use. This is just one of the 4 factors. It may be, depending on the circumstances, but that is read fairly narrowly, that nonprofit educational purpose. And so in evaluating that the first factor, it could be that you are using it in a way that still can be considered somewhat commercial or to the benefit of the organization, for example, for fundraising or for membership education, that still bring in a benefit to the organization that a plaintiff may argue is not truly nonprofit. So that may weigh against you on the first factor. Even if you are found to have it be a nonprofit use and that factor weighs in favor of you, there are the 3 other factors that could impact you. So it's important to look at each one of the factors in each circumstance and not assume that just because you're a nonprofit organization, you're automatically going to fall under the fair use exception. You might, but you have to look at all of the factors. Okay, so let's talk about the practical considerations given sort of where we are right now with the law being somewhat uncertain and still developing. So licensing. This is, I think, sort of where things are moving right now. Again, the U.S. Copyright Office in its report proposed this as a marketplace solution, citing that many stakeholders believe that this was the appropriate solution. And in fact, it does seem that it's coming to pass that there is increased licensing as a potential marketplace solution. There are various reasons for this and lots of speculation as to why that may be. It may be from some of the pressure from the ongoing litigation. So certainly that Anthropic settlement that we saw was a direct result of the litigation. It could be, trying to avoid the risk of litigation. We're seeing more licensing. Other theories that folks talk about is the sense that there is a need for really quality content. And if content is not paid for, it will stop being created and we will stop having quality content on which the large language models can train. And so that there is a value proposition to the developers to make sure that there is still good content being created and value to them paying for it. And I'm sure there are other reasons as well, but those are some of the ones that are talked about. Examples of licensing that we're seeing, and these are just, in the news and being publicly announced. OpenAI over the last couple of years has licensed from various news and media companies. News Corp, I think it was about 2024, they started licensing from News Corp. Again, the Anthropic example we just talked about. Perplexity has a publishing program. They partner with different media companies. Time, Fortune, Texas Tribune are listed. Amazon announced a deal with the New York Times. So these are just publicly announced ones. There are certainly many going on behind the scenes. where we have seen, people with data, people with content, organizations with content licensing those. And then on the other side of the spectrum, entities who are developing and their large language models and looking for data on which it should train. We've seen a lot of licensing and looking to get good quality content. The next topic we have in thinking about this is enforcement. So if you are not currently licensing and you think that there's ongoing scraping or taking of your content, what should you be doing about it? Of course, there's the option for litigation. We're seeing a lot of that go on, kind of looking backwards. But looking forwards, there are some options. So there are regulations in development, guidelines that different organizations are coming up with. But in the meantime, there are, and I see a question, what does TDM mean? It's text and data mining. So there are many people have heard of the EU AI Act that allows for text and data mining exceptions. There are many countries that allow for text and data mining exceptions where entities are allowed to engage in text and data mining in order to train algorithms and models, including AI. However, there may be opt-out exceptions to that. So if the EU AI Act, for example, provides that text and data mining may be permitted, but not if the owner of that content has opted out of the text and data mining. So in your terms of service, you should have opt-out language saying we opt out of text and data mining. That the EU AI Act says that it has to also be machine readable. So a robot.txt file would serve that purpose, as well as language in your terms of service. So options like that will help to at least ideally, if you're dealing with legitimate actors, stop them from using your content, or it will facilitate you being able to enforce and not be faced with the text and data mining provisions. There are also a growing number of technology measures to address this. So we're seeing Cloudflare is a good example. They have, if you have a domain name that is run through Cloudflare, they are now blocking AI crawlers. So rather than having to opt out, Cloudflare says we're automatically opting out all of our domain names that are under our umbrella from AI crawlers. You have to opt into it, or you can choose to monetize it. And so they've set up a program where if you want to allow AI crawlers, you can monetize that using their program. I'm sure there are other companies who are developing similar programs that will be able to be used. And then SynthID, I've flagged here as well. That's a Google tool, a little bit different, but that creates a digital watermark on anything that's AI generated. So that's another issue is how will we know what is AI generated and what is not? Sometimes it's obvious, but many times it's not. And so this is a tool that Google developed that will have a digital watermark on AI generated content. Of course, that's not all content, it's just some of it, but I think we're starting to see development of more of these tools to try and control the content and try and help content owners monetize or prevent the use of their content for training. So if you have an organization or you're part of an organization that has a lot of content, there are technological measures that you can be looking at to try and make sure you fit within the regulations that are out there already, making sure you have those robot.txt opt-out options in place, and that maybe you're looking at the different tools like what Cloudflare offers or others offer for blocking crawlers to your site. Okay. And then AI use and governance, and internal policies. So taking all of this and going to your organization and saying, now what? Because the fact is, not everyone, many people want to use AI, and many people in your organization want to use AI. There are benefits to it, certainly from the efficiency perspective. And for a number of years, we saw sort of companies and organizations just saying, no, we're not going to use it. But more and more, increasingly, we're seeing organizations allow the use of AI tools and providing to their teams internal policies on AI use. And as part of this, there are many different considerations, many that we talked about with, the output, as well as the input and controlling that. But you sort of start thinking about the AI governance. How do we want to use AI as part of our organization? And that can be a broad swath of discussions. More specifically, we want to develop probably policies that you make known to your certainly internally, your team, but also members, volunteers perhaps who are contributing, the vendors that you use. You'll want to talk to them about what your AI use guidelines are as well. So for part of this, we've got listed here the input consideration. So many organizations will simply say no proprietary information can go into the input. When I say input, like the prompts or maybe the content that you're putting into the AI tool. And so you want to be protective of that. You'll want to think about what protections surround that input for the particular tool that you're looking at. Different tools will treat that input differently. Some of them, again, like a free tool, may take that input and reincorporate it into their model. And so there can be additional concerns with how it gets used. Maybe the enterprise versions don't allow that, and we'll keep it more protected. Then there's the output. So how is the output from that used? And maybe your inclination is, oh, we don't mind too much, but it could be that your marketing team is using the tool to create an advertisement, say, or some sort of promotional material. If it gets re-put in and can be used by some third party, you don't necessarily want to see someone else using the exact same output that you created. And so thinking about how the outputs can be used and whether they can be reincorporated into the tools matters as well. So again, considering what the tool terms of service say and which tools you're using. And so that goes to this second piece, the AI tool selection and approval. We've seen many clients develop checklists for what's most important to them. What are they concerned with, and what should they be looking at when they're evaluating different tools? Does it matter how the input is used? Does it matter whether they have ownership rights in the output? Does it matter to them how many seats they have, how many people are going to be using it? So there are a variety of different considerations there, and that is very useful to create is a checklist to walk through those as your team members come to you and say they want to use a certain tool. Regular training, of course, is important. If you have a policy but no one knows about it, that's not going to do much. So regular training on these issues, and again, especially for organizations, talking to your volunteers and your members and your vendors that you may be using about your policies is also important. And then beyond copyright, which is certainly beyond the scope of this presentation, but there are many other issues that come up with these tools. Privacy issues, the data security issues that we flagged, bias issues, which have been talked about a fair amount, especially if you're using these tools for any sort of decision making and hiring decisions. Bias is a concern. And then misinformation, we certainly have seen a lot of deep fakes and other misinformation or hallucinations coming out of the tools. So those are things to be concerned with as well, and to be monitoring as you're thinking about your internal policies. Okay. The next piece I wanted to plug is there's a lot going on, as we've talked about. We have a podcast from the IP division of Venable about AI and IP. Our first episode is next week, Tuesday, and it will be additional episodes coming out after that, talking about these issues. So it will be a really good way to try and keep up with what's going on in this space quickly. So we've got a QR code there, and so you can find it on Spotify and other podcast providers. And I also wanted to provide the CLE code one more time before we wrap up. It's copyright 2025. Again, no spaces, just one word, copyright 2025. So with that, let me see if there are any other questions that came up in the chat. We have just a couple of minutes. Okay, so someone mentioned that they have an AI policy for their team, but haven't considered it for members. And, is there an example? Certainly, it's something that you'll want to think about more broadly, especially I would say with if you have speakers creating content for you for, your annual show or annual meetings, things like that, you'll want to have policies in place with them, very similar to how you would with any vendor. And then using whatever your rules are internally, thinking about should they be any narrower for your outside, for your members or your vendors, or perhaps it should be modeled on those internal policies as well. There is another question about the guardrails that have been put in place by different generative AI providers and how they work. I don't know. I don't unfortunately have all of the AI programming expertise. But my understanding is guardrails have been constructed and can be constructed to limit outputs. And so there are tools that will limit, for example, not outputting, and they can identify specifically certain trademarks or certain characters, or no Disney characters should be output. For example, there are different programs or tools that have done that. And Anthropic had put in court filings that it had used guardrails to ensure that the outputs would not spit out full copies of the books, for example, that they were trained on, and that they would not output exact replica copies of content that it was trained on. So there are certainly technological ways that they're doing it. The effectiveness, I'm not sure of. And the question goes to how transparent are they? I think with a lot of these technological tools, it's like the algorithm. A lot of it's behind the curtain, and we don't have full insight into that. Thank you very much for everyone's attention today, and please do feel free to reach out if there are further questions on this issue, and we will do our best to keep you updated with this changing environment. Thank you, everyone.